Welcome to the Business Sales Podcast. This is Rich Sierra with the Florida Small Business Legal Center. This is episode 152 of the podcast. Thank you for listening. I took a few weeks off to go with beautiful wife Sharon to France. She's my live studio audience today. Hi, how are you? And so we took a few weeks off and we had a fantastic time in France. Certainly would love to go there again. I want to shout out to somebody that recognized me on the vacation. I want to shout out to Al and his beautiful wife, Donna. He was at the cruise and he said, "Hey, you're the guy who does the legal podcast." So I never imagined that I was going to be recognized at all places in France. So that was pretty cool. And Al, hope you enjoy your vacation. Hope we get a chance to meet again. And also a shout out to the people, Claudia and Pepe for LLV Travel, for putting together a great cruise and a great vacation. They were our guest a few months ago here on the show, and certainly would love to have them back here again. So we're back on track. This is episode 152 of the podcast, and today I want to talk something that really affects every business owner. And if you're listening to me today, it affects you. Very likely, if you're a business owner, at some point you have paid someone as an independent contractor or a 1099. So today the topic is the 1099 trap, where your contractor is really an employee. And I've spoken about this before, but today I want to really do a deep dive a little bit more on this subject because I see this happening often and it's an avoidable issue. Okay, maybe you hire like a driver, a bookkeeper, or somebody that comes into your place of business, and you set the hours. They require to come a specific time period, and you at the end pay them a 1099 because they're quote unquote independent contractors. Uh, the and by doing so, you don't withhold taxes, you don't pay overtime, you don't provide any benefits. Although there's no requirement for you to provide any benefits, if they're an employee, you're required to withhold certain taxes. We're going to go over that as well. And you may believe that they're independent contractors, even though they may have an independent contractor agreement, but in reality, those workers may be employees. And there's significant penalties and consequences by misclassifying workers as independent contractors versus employees, and I want to talk about that today. And what under federal law, what the Department of Labor looks for is what is called the economic reality test. They really don't care whether you have a contract. You can call them anything you want to, but they look at certain factors that we're going to discuss today, determining whether or not they're independent contractors. Some of it might be common sense. So I just want to, discuss that with you as well. What is at stake here? Why this matters? If you misclassify a worker, you can have significant penalties. Okay? If the Department of Labor or the IRS determine that your independent contractor is really an employee, you could be liable for back wages. Minimum wage plus overtime for every hour going back up to 3 years. You can be liable for unpaid employer payroll taxes, Social Security, Medicare, and the federal unemployment payroll tax. There might be penalties and interest on unpaid taxes. You also may have potential state level penalties under Florida law and your state's unemployment workers' comp systems. So there are significant penalties as a result of doing so. And this is a very pro-employee statute. The law regarding, protecting your wage and hour laws are very pro-employee, meaning that if you do not have the proper records, how this happens? So how can I get involved in a situation that I have to defend myself in a wage and hour type situation? So you're paying this employer as a 1099 contractor for years. You're required to come in Monday to Fridays, 9 to 5, and you terminate this employee. Then the employee goes to file for unemployment compensation because they were terminated, and then they find out that you deny the claim because they were not technically an employee. Then the employee goes to an attorney who specializes in wage and hour law and recovering unpaid wages. That's when it becomes interesting. The attorneys that specialize in this practice, and I'm going to see if I can bring somebody in to talk to us about this, they do this for attorney's fees. And in many cases, the attorney's fees that they can collect from employers that do not pay properly their workers can exceed the amount of money that the employee may receive. Okay, I want to make it clear why this is important. I want to repeat this point to you. The attorneys who usually specialize in wage and hour type litigation, they do it on a contingency basis, and they do it for fees, statutory fees that they're able to collect from the employer that do not pay their workers correctly. So, in the way these types of litigations go is as follows. You get a demand letter from the attorney explaining why the employee is entitled to overtime pay, it is entitled to back wages, and you are obligated to pay them and also pay the taxes that you did not pay. You receive that letter. In some cases, people ignore the letter, which I've explained before. You receive any type of demand letter from an attorney, a law firm, do not ignore it. Have an attorney review it and discuss and respond to that. Because by ignoring it, you escalate the situation to the next level, which is a lawsuit. In many cases, these types of demands are settled. In some cases, do not. The employer may feel, no, I pay them. They were independent contractors. They were working only part-time for me. Therefore, I pay them correctly. The lawsuit begins. They start doing discovery. We talked about discovery before. In fact, my next segment, I'm going to talk about that as well. And you find out that you do not keep proper records. Or you find out that the records that you kept show that you actually had control over this employee. You should develop a schedule. They're required to show up there Monday through Friday. They are required to attend meetings. You actually set times for lunch, but you still pay them a 1099. In a situation like that, very likely your attorney would advise you to settle this claim as soon as possible. Do not let it escalate, because you might be in the losing end of this litigation, simply because it is likely, more than likely, that this worker who was classified as an independent contractor is an employee. Say you go forward and had a situation a few years ago which I was defending a client on any type of wage and hour determination. The way this is done, even if it's settled, especially goes to court, is that the employee portion of it is handled first. Okay? It's not combined, that you combine the attorney's fees with the employee's claim. The employee's portions are handled first. Once the court approves that settlement, then the attorney's fees are handled separately. So you'll be paying separate attorney's fees with the court's approval, but they're entitled to attorney's fees by pursuing this claim. Plus, you will have to pay your own attorney for defending the claim. So you're talking about 3 payments you already have if you're on the receiving end of this type of claim and it goes to litigation. You have your attorney's fees you would have to pay. You also have most likely a settlement for the employee for back wages. And then you have the attorney's fees of the employee that you would have to pay as well. So there are tremendous risks here. And if you are paying employees as 1099s to save a few dollars, to pay a few $100s a week, my opinion is not worth it. It is just not worth it because you can also be audited by the IRS. They find out that you're sending 1099s and they're really employees. So you have a situation that the IRS says, no, these are misclassified employees. You need to go back and we're going to impose additional penalties. The risk is too high to save a few dollars. It's not worth it. But that's my opinion. My recommendation, if you have any questions about whether an employee should be classified or a worker should be classified as a 1099 employee, 1099 worker, independent contractor, or an employee, talk to your CPA and get proper guidance or talk to an attorney. Okay, just don't on your own decide to do that. It's just the stakes are too high. So let me talk a little bit more about the economic reality test. And there are 6 factors. I'm going to list them and maybe talk a little bit more in depth about them. One of the key questions that the Department of Labor asks is whether the worker is economically dependent on the work they do for you. Okay, and I'm going to repeat that. Is this worker economically dependent on the work they do for you? Meaning that you're the only work that they have. If the answer is yes, it's very likely they're an employee and not an independent contractor. Okay. Another question that they ask, are they in business for themselves? If this worker that is doing work for you is this person that, like a graphic designer, for example, to do some brochures for your company, do a website, social media post, is this individual in business for him or herself, and they send you an invoice, they work remotely, they may meet with you occasionally just to, address some issues, but you really don't have any control over this work, this individual, then very likely this individual is an independent contractor because in addition to you, this individual may have other clients. So you cannot dictate the hours, the time, the place, whether they work. Those are the factors that the Department of Labor looks at when determining whether or not a worker is an independent contractor or an employee. So I'm going to list the 6 factors. Factor number 1, opportunity for profit or loss depending on managerial skill. Factor number 2, investments by the worker and the employer. Factor number 3, permanence of the work relationship. Factor number 4, nature and degree of control. Factor number 5, whether the work is integral to the employer's business. Factor number 6, skills and initiative. So I'm going to go some of these out of order. I'll drop the mic here. It is a podcast. We can do this. So I'm going to break these in a number of groups. Okay, so I want to talk about the control, the scheduling, and who calls the shots. I'm not going to jump through some of these. Factor number 4, nature and degree of control. And this is where many business owners get it wrong. Question is, how much control do you have over and how and when and where the work gets done? If you set the worker's schedule, assign specific tasks, supervise how they do the work, require them to be at your location, prohibit them from working for anyone else, that looks like an employee. On the other hand, if the worker decides when to work, how to do the work, where the work is done, and is free to work for other clients at the same time, that looks like a contractor. And sometimes the lines are a bit blurred. If, for instance, if you hire a freelance graphic designer, I'll keep using that example, but you require them to be in your office 3 days a week, attend staff meetings, use your systems, follow your brand guidelines, they can consider that control. The issue of the brand guidelines, I kind of disagree with that. Your brand is your brand, so you can have an independent contractor, a graphic designer follow your brand guidelines because they're your brand. So I'm not really, I don't agree too much with that premise. But the key issue here is whether you exercise control every day of this employee, whether you have also the right to control them. So, and how the work is performed. So you have to kind of, that's really a nuance there. And if you have any questions on that about a specific worker doing the work for you, which you're classifying as an independent contractor, you're not sure whether the independent contractor or employee, talk to your CPA, your attorney to give you better guidance. But these are general examples. And my goal here is to really give you an awareness of what the IRS, what the Department of Labor is looking for in determining whether or not this particular worker is independent contractor or employee. Uh, Factor number 3, permanence of the relationship. Is the work that the worker is doing, is that day to day? I mean, nothing, there's no such thing as a permanent job, but if it's something that is an expectation that they be working Monday through Fridays for you over a period of time, and the only time it terminates is when you terminate the employee, the worker, or the worker resigns. So that's what they call impermanence. Versus if this is more of a project by project basis, that you give a project to this individual, they complete the project, they leave, you could call 6 months later. So it's more sporadic versus ongoing. So that's one of the things they look at as well. Also, the worker only works for you and has been doing it continuously. That is a red flag. Very likely that individual could be classified as an employee. So, questions to ask yourself: do I control when this person works for me? Do I control how they do the work? Do I restrict them from working for others? Is the relationship been going on for months or for years, or is a defined project? And if the answer to these are yes, you most likely have an employee, wherever you're classifying them as an independent contractor and issuing a 1099. This is factor number 1, opportunity for profit or loss. Can the worker make money or lose money based on their decisions? In essence, that they're working on their own business and necessarily, they're making independent decisions on their own business, not on yours. So that's key. And an example is a true independent contractor can negotiate on price, can negotiate in scope, can negotiate when the work is going to be done, can negotiate in the deliverables. An employee doesn't have that type of flexibility, especially if he gets paid by the hour on a weekly, bi-weekly basis. An independent contractor makes decisions that affect profit and loss, pricing strategy, hiring assistants for the business, investing in equipment, and taking risks. An employee will not do that. So again, these appear to be common sense, but there are a number of business owners that continue to do this. And then they call me when, hey, listen, I got this letter, what should I do? So this is more food for thought, that if you have independent contractors, perhaps might be a good idea to reevaluate. Maybe they need to be reclassified. And there's some good news here for you that I'll tell you in a few minutes. And factor number 2, investment by the worker and the employer. Does the worker invest in their own business, their own tools, equipment, office space, marketing, insurance? Or do you provide everything for the job? Do you provide office space? Do you provide, the staffing? You provide everything that the worker needs to do the work? Most likely it's an employee, not an independent contractor. In essence, a true independent contractor, they invest in their own business infrastructure, the kind of investment they make to serve multiple clients, not just a single client. So just keep that in mind. Factor number 6, skilled and initiative. Being skilled does not make someone a contractor. They're employees that are highly skilled, but they might be employees. The question that you need to ask is whether the worker uses their skill and initiative to market themselves to others, whether they invest in their own business, they have their own brand, uh, as opposed to working specifically for you. And again, some of them repeat themselves, but I want to make it a point that if you have control over this worker, uh, most likely will be an employee. Now, there's a caveat I want to tell you that some people try to work this runaround and run is that, and I've seen it before, that they have the employees create LLCs or corporations and pay those corporations, even though they require them to show up Monday through Friday. They pay them on a biweekly basis to the company. So I just want to caution you against doing something to find a way or a loophole to get around wage and hour laws. Okay, that's just not going to be helpful to you if you're, Department of Labor audits you, or the IRS, or the individual submits a claim for wage and hour, trying to find an end run to not pay payroll taxes. Again, the savings that you might be trying to benefit from may not outweigh the risk that you're taking by doing so. So just want to keep that in mind, but discuss that with your attorney and with your accountant. How to protect yourself? I mean, protecting yourself is basically at this point is common sense. The first thing you got to do is, if you talk to your accountant, your CPA, or your attorney, to determine whether or not you're classifying the employees correctly. That's the first thing that I would suggest you do. And to the extent that you have independent contractors, you can have them. I would suggest have an independent contractor agreement that outlines the scope of work, the payment, everything else, provided they're true independent contractors. That contract in and of itself is not going to help you if you still have control over them, over the worker. So that's just not going to help you. So my suggestion is do an audit of every 1099 worker you have and do the same analysis. Analysis can go something like this. Does the independent contractor set his or her own schedule and how the work is performed? Does the independent contractor provide his tools and equipment? Does he work for multiple clients and not you? Does the independent contractor paid through an invoice and not through payroll? And that's key. You can still pay independent contractor to payroll, but how is that generated? Is that through an invoice, or is it just automatically generated through a payroll system? Does the independent contractor has his own business entity insurance and business license? Is the engagement project-based with a defined scope and end date? Or is it ongoing, Monday through Fridays, on a weekly basis, and similar to what an employment relationship would be? So I want to make it clear that an independent contractor agreement will not override the economic reality of the relationship. That's what the IRS and what the Department of Labor looks for. What is the economic reality of the relationship? So if the contract says they're a contractor and you treat them like an employee, they're employees. So the Department of Labor looks for actually what happened, not what the paperwork says. So I just want to make you aware of that. Now, there's a program that I found when I was doing research for this podcast in the Department of Labor website. And if you realize that a worker should be an employee, and I would say talk to your accountant, your CPA, and find what is the proper way to reclassify those employees. And there's a program that the IRS has. It's called the Voluntary Classification Settlement Program. I'm going to repeat this. the IRS has a program called the Voluntary Classification Settlement Program. It's also known as V as in Victor, C as in Charles, S as in Sam, P as in Peter, VCSP, that allow employers to reclassify workers prospectively with reduced penalties. Again, this program allows the employers to reclassify workers prospectively with reduced penalties. It's very important. So if you're in a situation that you have 10 independent contractors and you realize that they should be employees, there's a program that you can take advantage of that would allow you to reclassify them and have reduced penalties. And from what I was reading also, it gives you a waiver of any type of claims they might have against you for past violations. So again, my suggestion, if you're in a situation like that, is to look into that program, but go with a professional to help you navigate that program. Don't just go ahead and start applying on your own. Have a CPA do it to make sure that you're doing it correctly, you're reclassified, and you get your books and records correctly, and you have a fresh start. But there's a program that you can do so proactively versus waiting for a letter from the IRS, which can actually be worse. Okay. So let me kind of recap what we talk about today in terms of the 6 factors of the economic reality test. Opportunity for number 1, opportunity for profit or loss. Can the worker make independent business decisions that affect their bottom line, or they just earn an hourly rate that you set? Number 2, investments. Does the worker invest in their own business, or do they provide everything, or do you provide everything that they need? Number 3, permanence. Is the relationship ongoing and indefinite, or project-based with a clear end? Number 4, control. Do you control when, where, and how the work is done? Number 5, integral to your business. Is the core work a core function that your company does? Number 6, skill and initiative. Does the worker use their skills and business initiative, marketing, building clients, and growing a business? The bottom line is this. What you call the worker does not matter. They sign a contract doesn't matter. Whether they get a 1099 doesn't matter. The Department of Labor and the IRS looks at what actually happened, the economic reality of their relationship. If you're treating someone like an employee but paying them like a contractor, you are exposed. And one complaint for one unhappy worker can open the door for a full audit, can open the door for other potential claims as well. Again, as I said before, is that the savings that someone may be trying to yield as of not by paying workers, independent contractors, do not outweigh the risks. It's the cost of doing business. Just do it. In that way, you don't have an issue. And something not in my line I want to bring to attention to you. If you want to sell your company later on, as part of the due diligence, you will have to provide payroll records and provide lists of independent contractors. And someone who understands due diligence will go through those independent contractors to find out whether or not they're true independent contractors or they're misclassified workers. If they're misclassified workers, you're running the risk that the potential buyer may pass on your company because that buyer may not want to inherit future audits or future headaches for misclassification of workers. So if you're looking at your company as a potential asset to sell in the future, my advice would be make sure all the books and records are clean, including paying workers properly pursuant to the proper classification. Don't shortchange that, because at the end, you might have a great company, great profits, the books look great, but this issue can come back later on and become a wrinkle, or become really more of a monkey wrench, so to speak, on a potential deal after you work so hard in your business. So I just want to give you some thought that it could affect the value of your business, or potential attractiveness for the business to be sold to somebody else if you have some payroll issues or misclassifications. And I have seen situations that somebody says, yeah, we pay somebody under the table in cash. Don't do that. It's just not good to sell your company that way. Okay. Hope you enjoyed this episode. I know it's a little dry, but I think it was important. If you have any questions about any topics we talked about before or this topic, please, you're welcome to send me an email at richsierra.com. My phone number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. We're also in YouTube. If you want to see the video of this podcast, we're on youtube.com/Richard Sierra. Remember, check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. Available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. If you like the podcast, please give me a review. Certainly appreciate it. Give us a 5-star review, write something, share it with your friends. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.